Okay, I see people streaming in. We have now reached the 70s, so 70 plus participants. Let's give it a few more moments before we officially start, so that everybody has a chance to come in, and then we will kick off. Okay, Louis, have we reached now everybody who wanted to come in, or are there more people waiting?
I think there's still a couple of people slowly streaming in, but you're free to go ahead and start.
Okay, let's give it a few more moments and then we start. Okay, I suggest we kick off. Welcome, everybody. My name is Alex Turk. I'm the Interim Executive Dean of the Dickson Poon School of Law. And I have the great pleasure of welcoming you to the Criminal Justice After COVID-19 talk of tonight as part of the Future of Legal Practice series of our Professional Law Institute. We are particularly excited to welcome our speaker of tonight, Max Hill QC, who is the Director of Public Prosecutions, and who will basically tell us a bit more about how criminal justice matters were approached during COVID and what lessons we can learn, what technology can do for us in the future. And a very warm welcome on behalf of the school to you, Max Hill. And thank you very much for making the time. It's a great pleasure and privilege to have you. I will now hand over to Professor Saidov, who is going to introduce our speaker in greater detail and will also tell us a bit more about the format of this event. Over to you, Jagongkir.
Thanks very much, Alex. And good evening, everyone, and thanks very much for joining us this evening. As Alex said, my name is Jahangir Saidov. I'm Professor of Commercial Law here at the Dickson Poon School of Law and the Director of the Professional Law Institute. Let me start by saying a few words about the work of the Institute. The Professional Law Institute provides a focal point for legal profession and practice-based education, research, and civic engagement. At the Institute, we seek to strengthen connections with practitioners and stakeholder institutions in the heart of legal London. The Institute brings together a series of connected activities. They include practice-based research, the King's Legal Clinic, and professional education programs, such as our newly launched and innovative MSc in Law and Professional Practice that will enable our students to develop not only cutting-edge legal expertise, but also a comprehensive set of practice-ready skills. Another important part of the activities of the Institute is its Future of Legal Practice series. In this series, we explore some of the most topical legal themes and challenges that the legal world is facing going into the future. Our session today is part of this series, as Alex said, and the spotlight is on criminal justice after COVID-19. We're honored and absolutely delighted to warmly welcome our distinguished speaker, Max Hill QC. Max Hill is the Director of Public Prosecutions. He was appointed by the Attorney General and took up post on the 1st of November 2018. Max was born in Hertfordshire in 1964. He attended state primary schools and following a move to Northumberland, the Royal Grammar School in Newcastle upon Tyne. He won a scholarship to study law at St. Peter's College, Oxford between 1983 and 1986. He qualified as a barrister in 1987 and was appointed Queen's Counsel in 2008. While at the bar, Max both defended and prosecuted in complex cases, including homicides, violent crime, terrorism, high-value fraud, and corporate crime. He was instructed in many of the most significant and high-profile murder trials in recent years, including the second set of trials concerning the killing of Damilola Taylor and the London bombings of 2005. From March 2017 to October 2018, Max was the independent reviewer of terrorism legislation. As the independent reviewer, he complied reports, including an investigative review of the use of terrorism legislation following the Westminster Bridge attacks. Max was also the leader of the Southeastern Circuit from 2014 to 2016, chairman of the Criminal Bar Association from 2011 to 2012, and chairman of the Kalisha Trust from 2014 to 2018. Until his appointment as the Director of Public Prosecutions, Max was head of Red Lion Chambers. I'm also very pleased to welcome our colleague, Dr. Hannah Quirk, who will lead the conversation with Max Hill. Just a few words of introduction. Hannah is a reader in criminal law here at the Dickson Poon School of Law. Her research interests developed her previous work as a case review manager at the Criminal Cases Review Commission and focus on the changing culture of the criminal justice system and the increased difficulties that defendants face following the curtailment of the right of silence and the system for getting disclosure of unused material. This feeds into Hannah's work on miscarriages of justice. She's also interested in sentencing and the criminal law, in particular, homicide offenses and the partial defense of loss of control. And just finally, a few notes about our format this evening. Max Hill will start this session by initial overview talk for about 20 minutes. Hannah will then lead the conversation with Max for about 40 minutes. And we will then open the floor to questions from the audience. Now, you will need to submit your questions, so type them in the question and answer box on Zoom. And the session is scheduled to take place until about 7:30. So that's it from me. And I now have the pleasure of passing the floor to Max Hill. Max, thank you and welcome.
Well, thank you very much indeed. Hello, everyone. It's a pleasure to join you this evening. It is 2 years ago today that all of our lives had just started to change, because the night before, we had been asked to stop all non-essential contact with others and all unnecessary travel. And a week later, we were in full lockdown. It was a terrifying time, frankly, and it marked the beginning of a period of greater magnitude and trauma than any of us could have imagined. The impact of COVID-19 and the pandemic will stay with us for some time to come. That's personally, professionally, and across our entire society. Now, I know that this series of events is about the future of legal practice. So I hope you'll forgive me for an initial reflection on what has gone before. But in looking to the future, we need to first understand both our past and our present, and particularly after the unparalleled period that we've all experienced. So this evening, I want to outline how we at the Crown Prosecution Service are playing our part in the recovery of the criminal justice system. But I will then go on to consider how we might do more than just recover, how we might improve the system for the future, and do that particularly for victims and witnesses. The pandemic was an unprecedented test for the criminal justice system, but in managing its impact, in keeping the wheels of justice turning in the most trying of times, we proved what was possible. Alongside our partners, the CPS played a key role in ensuring that the criminal justice system continued to operate throughout the pandemic, and I suggest that was a very significant achievement. Unfortunately, it was just not possible for the system to run at its normal scale and pace during the worst periods. That meant that by September 2020, the CPS live caseload was 80% above the February 2020 pre-COVID baseline. We have made significant progress since then, but the live caseload as I speak to you is still 32% above that baseline. The effect of delays, particularly in the Crown Court, are serious. For victims and for witnesses, prolonged waits can impact their ability to move on with their lives. Defendants, including some held in custody, are also seriously affected when they must wait longer for their trial. So we need to be as creative and determined in tackling the backlog and mitigating the impact on those in the system and shaping the criminal justice system of the future as we were in responding to the immediate impact of the pandemic. Within the CPS, we are playing our part to clear the backlog whilst ensuring best possible service for victims and witnesses. We are focusing on ensuring cases are ready, and we're working with partners, both nationally and locally, to make sure that hearings are effective. For example, in the West Midlands, police, the CPS and HMCTS, that's the Magistrates Court and Tribunal Service, have been working together to identify trial cases listed in 3 weeks' time, identifying and addressing outstanding issues early to ensure that the case can proceed on the day. Also, we are recruiting. Over the past year, our workforce has grown by 5%, and that includes an additional 88 senior Crown prosecutors and 112 paralegals and administrators. This has provided additional capacity to deal with backlogs, and it's helped us to prioritize cases involving rape and serious sexual offences. But we are not stopping there. We will continue to grow in the year ahead, including a programme to develop our own experienced prosecutors for the future. And here I want to mention our paralegals specifically. In the Crown Court, our paralegals play a crucial role supporting victims and witnesses and ensuring the smooth running of cases, particularly trials. So we are significantly increasing their numbers in Crown Courts to manage the increase in caseload and ensure that we can continue to deliver high levels of service. We're also about to embark on a pilot scheme deploying paralegal officers to our magistrates court teams, so they will attend court to support victims and witnesses in more serious cases, including youth cases. And we are reforming how we communicate with victims, because we recognise that our current service needs to be improved. So we commissioned research into victims' needs, and we'll use the findings to overhaul our model of communication, making sure we improve the support we provide to victims of all types of crime. Others across the system are also playing their part, but each partner individually carrying out its role to the best of its ability will not be enough to eliminate the backlog and to improve the system to the standard that we all want to see. We need to work together as never before. We need strength in all parts of the system, and we need to consider what needs to change. So recovery does not mean reverting to March 2020. We must aim higher. So I want to explore with you a few ways in which we think the system could be improved. Let me start with digital technology and remote hearings. We are one of the most, if not the most, digitally advanced prosecution services in the world. But that does not mean that we can be complacent. We need to continue to invest and to innovate when it comes to digital technology. And that includes developing a consistent national approach that makes the best use of remote hearing technology, which is a vital piece of the puzzle in terms of allowing courts to operate at the higher capacity required to clear the backlog. Remote hearings were introduced at an astonishing scale and speed during the pandemic. But that means that currently there is inconsistent adoption and confusion around the best way to use technology. Remote hearings are not always appropriate. There are certain types of hearing which it's important to hold in person. To my mind, this clearly includes trial hearings. But that's why I advocate a mixed economy approach. Hearings that cannot take place virtually should absolutely continue in person, but those more straightforward hearings that have already worked well remotely should continue virtually. Let me also mention jury bundles. This is one of the last parts of the criminal justice process which remains paper-based. And let me give you an idea. On the first day of a standard trial, perhaps lasting 1, 2, or maybe 3 weeks, each juror is presented with a bundle of material that is about this size, A4, pack full of paper, in every trial. So that's a paper jury bundle. It's out of step with the modern digital first justice system that we want to build. They're costly from an environmental, a financial and resource perspective, and they make flexibly rescheduling cases at short notice very difficult. So we are therefore working with partners across HMCTS, the court service, and the judiciary to trial a digital solution. And that means the jury will access their bundle on a tablet. This has been used effectively in some larger complex trials, but we want to work towards it becoming normal practice for all cases. We need to carefully consider accessibility and indeed propriety, so ensuring that tablets are stored securely and individually, and that all members of the jury can use these digital tools comfortably. Our priority will always be ensuring that trials can continue fairly and transparently. But we don't just want to keep up with the rest of society in terms of our use of technology. We also need to be looking ahead to future opportunities such as AI, artificial intelligence. And when we consider how we can use AI, we need to look at our processes and ask the question, what can helpfully and safely be completed automatically or with the assistance of AI, and what requires a human to make decisions? This is not about taking humans out of the process. Our casework decisions will always be made by highly trained prosecutors exercising their judgment. But our digital teams are currently developing several solutions which use AI and/or automation, all of which are in prototype or early development stage. For example, we spend a huge amount of time checking documents to make sure that all personally sensitive data has been redacted to avoid any risk that details not relevant to the case are inadvertently shared. We're exploring how we can use AI to automatically highlight this data, which would make redaction faster and more reliable. We've been working with several police forces to support their piloting and adoption of AI tools for their investigators, ensuring that these tools can meet the requisite evidential standards. Now, while these projects remain in their early stages, we hope that ultimately they will streamline the administrative demands of our work, freeing up our colleagues to focus on what really matters: high quality decision-making, careful case building, and professional support for victims and witnesses. Let me move on to an aspect of court hearings. Court time is at a premium now more than ever, so we must make the very best of it. Our response to the pandemic clearly demonstrated the value of cross-system cooperation in finding the best solutions to the challenges we face. We must not lose that. For example, the listing of court cases, so when they will be heard and where, is a matter for the judiciary, but its success relies on all parts of the system working together. As a system, we need to focus on victims, witnesses, defendants, those most impacted, and consider how we can best prioritize cases and hearings. And one word of caution: it is not as simple as list as many cases as you can. And that's for at least two reasons. First, if more cases are listed than the court has capacity for, some will be postponed and at short notice. And that leads to uncertainty for everyone. Now, this is sometimes unavoidable, but we must minimize it wherever possible. And second, every case listed needs to be prepared. And so each lawyer and paralegal can only prepare so many cases. So if cases are listed that the court then does not have time for, effort has been wasted, and we can ill afford wasted effort. But can we also go further and consider whether there are some more fundamental changes that we can make? For example, does a key part of our system, and that's appeals, strike the right balance between fairness to defendants and fairness to victims and witnesses? Let me be clear. The right to appeal a court's decision is a vital safeguard. But should defendants who want to challenge their conviction automatically be given a whole new trial, with all the implications for the system and victims and witnesses? Because that is our current system, with appeals from the magistrates or the youth court. Now, unlike appeals from the Crown Court, the defendant does not have to demonstrate to judicial satisfaction why their conviction might be unsafe. They simply ask, and they are given a new hearing in the Crown Court. And that means that victims and witnesses have to give their evidence all over again in a fresh trial, despite a tribunal having already convicted. And particularly when Crown Court backlogs are so significant, they often face a significant weight to do so. The first trial and the evidence they gave count for nothing as the process begins again. And it's therefore unsurprising that some appeals succeed simply because witnesses do not attend the new hearing. And I should highlight that this system includes youth court cases in which the victims and witnesses are often children and which may involve serious offences such as rape. Now, any decision on this issue would, of course, require careful cross-system discussion, and I'm clear that the right to appeal a decision must remain. But why not adopt a system like that from the Crown Court, which requires permission to appeal from a judge, which would sift out cases without merit? It would make the system more efficient and a great deal fairer. And when an application for permission to appeal is granted, why not do as we have long done in the Court of Appeal? Decide the appeal based on an accurate record of the trial proceedings without witnesses having to come to court to give evidence all over again. Now let me move on to another area affecting victims and witnesses. The current way in which witness evidence is adduced has not kept pace with modern technology. The process of providing live evidence to the court should not be a test of a witness's memory. And in some ways, our current system relies on outdated assumptions around witnesses and the purpose of giving evidence. So how can technology help us here? Well, might the court and justice be better served if witnesses recorded a video statement at an early stage in the proceedings, which is then played as their evidence in chief? This already happens as a special measure for vulnerable victims and witnesses and certain intimidated victims. But might it be of benefit for a wider range of victims and witnesses? And might body-worn video, which police officers automatically record at crime scenes, be one way to record these statements, particularly in more straightforward cases? This would, for example, enable the police to record a witness statement from the complainant at the scene of the crime, and for the witness to subsequently affirm the truth of its contents, either in a written statement or a further video recorded interview, and if called to give evidence, on oath at trial. The advantages of extending the use of body-worn video might include better representation of the immediate impact of the offence, capturing both the emotion and the environmental context for a judge or jury, and speeding up and improving the way police obtain evidence from victims and other witnesses, enabling them to submit stronger cases to us at the CPS. There would, of course, need to be certain safeguards. The witness would need to understand that they were giving a formal statement. They would need to have the opportunity to add to or clarify their statement outside the heat of the moment. And of course, cross-examination must still be available. Now, let me just take a step back from the broader system and into the CPS. Here, it's our people who are at the heart of everything we do, and it's our colleagues who will rise to meet the challenges ahead. As we look to the future, we need to be the best that we can be. And as we welcome new faces, we continue to focus on making the CPS a truly outstanding place for all of our people to work. This includes nurturing existing talent through a range of in-house development programs, including our prosecutor pathways, which support colleagues from a range of paralegal and administrative roles into legal careers. We have a legal trainee scheme that is recognised as one of the best available to aspiring solicitors and barristers. and we have a comprehensive learning support offer across each of our 9 professions. So we pride ourselves on fostering a truly inclusive culture, supported by strong relationships with our excellent staff networks, and we prioritize well-being, which has been so important throughout the pandemic. So in closing, the past 2 years have tested us all, and in so many ways. I am incredibly proud of how we responded to those tests, how we worked collaboratively with our partners, and our response gives me confidence that we can meet the significant challenges that remain. It also makes me even more ambitious. We have shown what we can achieve against the odds. So let's take that determination, that creativity, and apply it more widely to make our criminal justice system the best that it can be. Thank you.
Thank you so much, Mr. Hill. That was so much you packed in there for us, and some really exciting ideas from a research perspective, from a practice perspective, and for our students to think about. And if the Royal Commission on Criminal Justice ever gets off the ground, I think there's some really exciting ideas it could focus on there. If we could start by going back 2 years, we're sort of coming up to the anniversary, as you said, and I'm sort of interested in the practicalities of what you did. I'm assuming you found out before the Prime Minister made his announcement on television. 3 years ago, I wrote a paper with a colleague about criminalising breaches of quarantine, which we never got around to writing up because we thought it was one of those abstract ideas we had plenty of time to do. So if I could go back in time, I'd have written up this paper that would have been quite useful. What would you like to have known then that you know now? Or...
Yeah, I mean, I suppose I have to start, Anna, by saying, actually, we didn't have really any more notice than anybody else did. You know, a decision which was dictated by the science at the time, announced by the Prime Minister, you know, in an 8 o'clock broadcast, came to all of our staff, you know, just as it did to the whole population. So I don't think that we were in any special position. But we could see the way that things were going. And as I said, 2 years ago today, we held our breath. We said to over 5,000 staff here, please go home, leave offices, take your laptop with you, and log on as usual in the morning. And I don't think any of us could have quite known how successful that would be. We have said that we are digitized. We're a digital service for about 3 or 4 years prior to pandemic, but it's never been tested in this way. And we have a minority of staff, it's what we call CPS Direct. They are our out of hours 24/7 service, who have always worked remotely, literally from their homes at all hours of the night, taking calls and cases from the police in order to give advice and to charge them. But for the vast majority of our staff, it was office-based. So we were, frankly, astonished that it worked and that everything switched back on the next morning. And I can tell you that we didn't suffer a loss of productivity. And I think, frankly, we could have been forgiven had it taken us longer to get back up and running, but that isn't what happened. What did we learn very rapidly that I suppose had we known it was coming, we would have trialed, to follow your question? That's about not just being digital, but about being national. You know, I sometimes say the CPS is the largest law firm in the country, which is true. And our headcount, for anyone who wants to know, is 6,500 and rising. I predict it will go through 7,000. So we're a very big organization. But what we did in lockdown in particular was to use the digital process to ensure that casework could be continued wherever around the country. So for an example, teams of prosecutors who were involved in some of our more specialized areas where, due to slow running of the courts, none of their cases were being listed, were able to help some of our geographical areas with what I call general crime cases to ensure that they were progressed at pace. And that was not about getting on the train and crossing the country, because no one was doing that. It was about sharing digitally the casework materials. And that was a huge lesson learned. I think if there are other examples that we've done and which we would know to use next time, I would mention what I think I just touched on, looking at what's coming up in a more cooperative way, looking at the court listing, of course, leaving it to a judge to make a final decision on whether a case is listed or not, but check what's ready. It's a process of triage and prioritization, a phrase I found myself using all the time through 2020. Also, trying innovative things. For example, in the Northwest, saying to a defense firm, let's try and list all of your cases on a particular occasion or in a particular week. That'll be easier for you because of restrictions on travel. We hope that we'll be able to use the cloud video platform, which is the remote link that was stood up at great speed. It was running from the first week of April. That was MOJ invention. And looking through those cases to see what was ready to go for the next stage. And we had in the Northeast last year what were called trial recovery courts. So listing, extensive liaison with the defense, and actually driving results sometimes without things having to work all the way through to the trial. What I put alongside that is a really careful regard to the public interest. As you will know, and maybe some others will know, a prosecutor looks at the evidential, what we call the evidential stage of the code for prosecutors, which is a published document for anyone who wants to see it. Where you have evidential sufficiency, you then go on to consider public interest. And we were able to put measures in place to try to bring forward certain types of cases when others had to move more slowly because of very restricted availability in the courts. And I think that added to efficiency in the early days. Having said all of that, though, there are some threads that run through criminal casework. And if I mention better case management, BCM as we all call it, and TSJ, which is transforming summary justice, there are a series of core principles which had been eked out years prior to pandemic about the speed at which business should move. That's not breakneck, nor is it slow, but it is a speed at which the whole system can operate, ensuring that the right things are done, the right things are thought about, the right documents are created, digitally, of course, to make sure that things move at pace. And we have, as a system, been reintroducing better case management principles where they were suspended out of expediency during the first part of the recovery. So, I mean, I think I could go on. The big thing is I didn't know how successfully this organization will be able to carry on without any break at all, and that is a testament to our staff. But there are a number of ways in which, with partners across the CJS, we've done things that we hadn't done before. And I think the criminal justice system as an entity has benefited from that. We've got to know each other better. We've spent more time, in all these remote calls in each other's company. And there are an element of work streams and comparative exercises as we progress cases, which we will now retain in the system, although they were first stood up, if you like, across the criminal justice system in the early days of the pandemic. So that's what I'd give you as a first offering.
Thank you. I think lots of organizations look to IT as it's future sounding and it can solve all our problems. I think big organizations like the NHS and the criminal justice system often find they just become mired in waiting for the perfect IT solution to come through. Obviously, the government has talked about the COVID backlog in the criminal justice system, but there were huge problems beforehand. The Lord Chief Justice talked about the decade of underinvestment in maintenance, the leaking roofs of broken lifts, broken heating, overflowing lavatories, etc. Is there a danger that we had put so much focus onto IT that when actually we need to fix the very basics first of all, that court systems haven't got the infrastructure? They've got no Wi-Fi at the moment, or many of them. So, I
mean, obviously, the maintenance of the court estate is is not for me. It's for the court service and it's for Ministry of Justice. But I think what I can say is that the health and safety and good working conditions in court are very close to us, because throughout the pandemic, we've had actually thousands, I was going to say hundreds, but I'm talking considerably over 4 figures in terms of staff headcount who have continued to work in court. So whilst for the vast majority of us as a population, lockdown meant working from home, that's not so for Crown prosecutors who were key workers, to use that phrase we all started to use, and who were going to court. And so we were very keen to maintain good conditions, health and safety. And a lot of that was specific to the issue of the day. So literally screening, cleanliness, mask wearing, social distancing. But it's broader than that. It's the fact that there is very heavy use of the court estate on a daily basis, and it's in our interest just as much as anybody else to ensure that that is maintained. So I don't think that focus has gone, but I have to repeat, it's not for me to resolve that, or to give instructions to the court service or the MOJ. But what I do think, though, to sort of tag on to what I've said about digital technology, is that the unprecedented advances that were made in the last 2 years should not be seen as a flash in the pan, emergency measures. They should now become permanently part of the structure. So I was very pleased actually it was on Valentine's Day this year, when the Lord Chief Justice announced that remote hearings should be here to stay. My phrase, not his, but what we have been calling the cloud video platform. Every lawyer is now familiar with CVP hearings. We saw a huge spike in their use in the summer of 2020, and then they've sort of waxed and waned according to whether we're in lockdown or not. And my view on all of that is that for the right kind of hearing, we should be easing the pressure on physical listing, and if you like, easing the footfall in court, and I suppose even the wear and tear in court buildings, by always having a component of our casework that is conducted remotely. This will not include trials. And of course, it cannot offend either the access to justice principle or the open justice principle, which are separate. So use of technology for remote hearings means that it has to be available to the user, and that includes a defendant, wherever they may be patching in from. They can't be put at disadvantage any more than lawyers can. But we've found ways of doing that, and I'm very keen that that should be maintained. So what I'm saying is, if you look in a courtroom, a courthouse now and in the future, you should be routinely seeing a mixed economy there. That in any individual court day or week, there will be a component of remote hearings, and they make space and in their way contribute to bearing down on backlog, which leaves more room for the physical hearings which are necessary, particularly for trials. And as you will know, the backlog is in a way worse in the Crown Court than the Magistrates' Court, because the average trial in a Crown Court has more moving parts, including juries, takes longer. And so we need to maximise the use of Crown Court buildings and courts for trials, which makes my point, I think, pretty obvious. If it's not a trial, well, we can do it remotely, and that's an efficient way of doing it. And the last point I'd make is, for lawyers, whether in the CPS or elsewhere, how much more efficient to appear on camera, from home or office. You can do multiple cases in a day, assisting the court, giving information that judges need, without ever having to get on the train and travel across the country and achieve only a single hearing in a day.
That's really interesting. And I think we've all transformed our ways of working. I wonder if there's something lost in the efficiency as well, though, in that you can't have the sort of serendipitous conversations or the chat with the client, and also issues around timing. A number of lawyers I've spoken to have said, having disclosure in advance, all these kind of issues. If everything works fine, then it's great. But again, it's almost like we're trying to put this superstructure on top of a system that can't bear the load of the current load.
Yeah, no, I think I absolutely accept that. And, this has to be a truly flexible mechanism and a flexible system. So you've just mentioned early disclosure. What we are doing right now as part of the Crown Court recovery discussion is, back to the word triage, which I used earlier, improving triage at an early stage to ensure that trials where they're needed are effective. But in the very next breath, we are prioritizing early service of the case in all bail cases, so that gives the best chance of informing and assisting the defense so that they can give instructions at an early point. And it's clearly in our interests for defense representatives to be on board at the earliest possible moment, to have material available. As I say, not necessarily at breakneck speed, but at TSJ and BCM speed, and I've used those initials already, because for the prosecutor at court or on a remote hearing, the more advanced reading can be done, the better. Now, you preface that question by saying, we've got to be careful not to stilt discussion and consideration of plea. And I absolutely accept that. And that's where I think flexibility has to be maintained. And there are many lawyers, and I'm sure many judges, who would say that it's when you have the participants in a case literally in the same physical space that there's the best chance of an outcome, which from our perspective might be the guilty plea. From the defense perspective might be, persuading us of various things that they need in order to be ready for trial. So I'm alive to that. And some of the recovery methods that we've used, I gave an example in the Northwest and another in the Northeast, have been about brigading cases, trying to give, if you like, an early warning of the content of cases and have an early discussion. In some instances, you need people physically present. In others, you don't actually. You just need better information and participation at an earlier stage so that reality bites and realistic decisions are made. So I would stick to what I say. I think it is about a mixed economy. It's neither all of one nor all of the other. But I think these cloud video hearings, if that's the phrase that sticks, they may use successor phrases, really should be a thing of the present and the future, because they made such a difference in initially opening up the system and bearing down on backlog that they must be a good thing. There's a lot of evidence of that.
That's interesting. I suppose timing is something that's very easy to quantify, and often what can get measured gets done. I think I'm interested in some of the more intangible effects around these changes. And you mentioned things like pre-recorded examination in trials. There's some evidence and sort of anecdotal talk about how if a witness records their evidence and either gives their evidence remotely or gives pre-recorded evidence, that has less of an impact on juries. In addition to some of the, evidential problems as well with having to try and cross-examine in advance without having received all the disclosure necessarily. So I wonder but these things are much harder to manage, to measure rather. And I think my concern is if we just focus on timing and backlog, that those more intangible issues, either whether people feel they've had a fair hearing or not, or the impact it has on juries.
Yeah. Look, I think that's absolutely a fair comment, and in my remarks, what I was saying, and I'll just expand on it a little, is that there will be cases in which it is efficient and expedient to take a recording of what the complainant says there and then, but there will be other cases in which it would be wholly inappropriate. And I'm thinking, for example, of rape and serious sexual offending, where in some instances the complainant will be able to give an account actually quite quickly, and that can be video recorded. In others, because of the trauma of what has happened, the system needs to be sensitive to that. And by the way, we give training on the neurological impact of trauma on victims to all of our prosecutors and have been doing so for a couple of years now. So you need to be sensitive to that, point one. Point two, there is a difference between talking to a police officer or being seen and recorded by a police officer on body-worn video and knowing that that recording is being made for the purposes of court, and literally what you say is equivalent to the written statement that most people who go through the system are familiar with, literally sitting down in a police station or at home with an officer with pen and paper on Section 9 Magistrates Court Act compliant documentation with the rider at the top, which all lawyers are familiar with. So we would have to import those elements. This is not just about quick justice, it's about robust process, and all of that would have to be absolutely included. And as I say, the ability to challenge is fundamental. Every member of CPS staff, me included, when they switch on their laptop in the morning, finds a banner going across the screen which talks about fairness and independence. Those are our watchwords. We are independent of all, and we're here to be fair to all. And that means balancing the interests and rights of witnesses, victims, and defendants. And we have to do that. And in the terms of evidence gathering, the right to challenge through cross-examination is fundamental. But we're already seeing in some significant aspects that being conducted pre-trial. And I don't think there is empirical evidence yet. I agree with you. You will hear anecdotes of those who will say that the impact of you were referring to Section 28, which is the mechanism by which in rape and sexual offences, a qualifying victim can attend court. Actually, sometimes they do it remotely, but can attend court on a date prior to trial to be cross-examined by defence representative, and that is then played into the trial. Some anecdotes will suggest that the impact of that being played to a jury is less than the impact of a witness in the room. Others will say, well, actually, sitting in a large courtroom, when you invite a jury to zero in on the screen and just to focus on that, whatever it is, 12, 18, 24-inch screen, the impact comes across loud and clear, and it can be extremely impactful and indeed emotional and distressing evidence. But I think it's not in every case that is what you do. What we're in the business of doing is providing fairness and balance, absolute clarity, and of course opportunity to challenge. But there is more than one way of challenging accounts given. And I do need to sort of come back to what I was touching on earlier in my comments. We've got to remember the re-traumatizing of a victim, whether of rape or of another crime, by requiring them in every case to come back into the system, if you like, a year or sometimes now 2 years later because of backlog, and to relive it live in court. Okay, some would say that's going to have bigger impact, but is it fair actually on the individual to make them do that? So, there are ways that we can support witnesses. It's not all about pre-recording. There are rafts of special measures that can be used, and I've actually made speeches about that quite recently. We need to use them all. But I think as a general point for efficiency of the system, without locking out fairness or trampling over any of the rights, including public access to justice, we should at least look at capturing digital innovation. And it's only a handful of years ago that body-worn video was completely new. We tend to forget that it's now routine. We didn't have it at all a handful of years ago. We are using it, I think, as a system to great effect because it shows in an unvarnished way what happened when the police attended the scene. But are we using it in all of the ways that we could? And tonight, I just want to start a conversation about whether we could go further whilst staying absolutely true to the rights and the balance that I've mentioned.
Thank you. CPS has become markedly more victim focused over the last 15, 20 years probably. And I've seen numerous measures have been brought in to improve things for victims. I can't remember the last one for defendants. Do you think there are issues around using the term victim, which perhaps prejudges or can be seen to prejudge the guilt of a defendant, and whether there's a danger of these rebalancing measures going too far?
I mean, I think, of course, it is right. It is always right that on a technical level, a victim is not a victim in court parlance until a conviction has been returned. And of course, it is right, therefore, that very often judges will insist on an individual being referred to as a complainant rather than a victim in the pre-conviction space. And so, I absolutely don't quarrel with that. And I don't think actually that the participants in the process misunderstand that. And I don't think that even were a prosecutor to use the word victim in a trial hearing, the jury would suddenly think, oh, well, this person's already been convicted because prosecutors calling it. So I don't think it is actually all that confusing. As a nationwide service, we, I have to say, are quite prepared to use the word victim from early stages. That's not because we're calling the case. It's because everybody understands what's being talked about there. And survivor, which is another commonly used word, technically has an inference that you've survived something. So you could say these are leading terms, but because they're in such common use, I really don't think we should be unduly hung up on the use of a word. The important thing is that you present a case, if you're a prosecutor, in a way that, of course, is robust, of course, presents the evidence available to you at its strongest. That's what you're there for as a prosecutor, but you absolutely respect the rights of the other side. And when it comes to that, we do focus on the rights of defendants. We focus on that when we're considering our code tests, including at the public interest stage on whether a case should be brought. And we focus on that at all later stages of the proceedings, bearing in mind that defendants are represented, that they do have legal representation in court, and in our adversarial system, in every trial scenario, there is equality of arms. There's a prosecutor on one side of the court, defense advocate on the other side of the court, and it's their job too to ensure that rights are upheld. So I do think that we maintain the balance. And, for example, I made a speech a couple of years ago about the need to do better when it comes to terminology on capacity. Capacity of defendants was expressly the topic what I was talking about, because we've been using statutory terms from Acts of Parliament of 100 or more years ago, which are ludicrously outmoded. And so we've done a lot of work here at the CPS at making sure that we look, for example, at disability in the correct way. We've moved from a medical model to a social model for anyone who's studied it. And that is saying, be aware of who you are dealing with. A defendant is a person, not just a number, in the same way that a victim is a person. So I know lawyers talk about cases all of the time, but I'm as confident as I can be that every prosecutor who makes a decision or who runs a case knows that they are dealing with real human beings, and these rights have to be balanced at all stages. And so, to finish, when we were under the most intense pressure with only part of the system up and running, we looked at our public interest, and with unprecedented delay in the system, we said to all of our prosecutors, you should be reviewing cases from time to time to make sure that it remains in the public interest to continue to prosecute a case where, for example, someone's been held in custody for longer than you would ever have originally envisaged when the case was charged. And so we did give interim guidance on that. So I do think there is balance. But I think also that we should remember that there's robust representation, often free at the point of need, to defendants in the criminal process, and that's a very necessary, valuable thing.
Well, there are increasing numbers not represented now, which I imagine is bringing its own problems too. Your predecessor but one left the bar for politics. I was wondering, would you see a similar route for yourself?
I think the short answer to that is doesn't enter my mind. It is a strange thing to come from private practice as a self-employed barrister, which my predecessor but one and I both did, where you can say anything you like, think what you like, and be as political as you like. But when you enter the CPS or any other part of the civil service, you're absolutely apolitical. And that's for good reason. That's how it has to be. When it comes to what happens when you leave, well, I haven't left yet. Ask me when I'm close to leaving, but I really don't know.
A very political answer. Many of the cases that have arisen over the last couple of years have been quite small p political, in terms of things like the protests during lockdown, the Coulson statue being thrown into the dock in Bristol, Julian Assange, unduly lenient sentences, Partygate, I imagine, will come up at some point. What are the difficulties for a prosecution service in dealing with cases that have such a political spin on them?
Well, prosecuting is not political. It's not a political act. It's certainly not a political function. So the independence that we have is real. So to give light to that, there is a framework agreement which exists between the person who holds my job and the attorney of the day. And that framework agreement was completely rewritten under the current attorney's predecessor. And I signed it with him in March 2019. And it was then amended and re-signed with the current attorney. And that's not just a piece of paper. That is a document which enshrines the independence, sets out those matters where, quite rightly, I will bring material to the attention of the attorney. And classically, that includes cases where actually it's she, the attorney, who holds the consent to prosecute. And there are still some aspects of that. But for everything else, it's our decision. That's what's been created by our enabling statute. And the authority to charge comes through me, and I delegate it, not in every case, but in almost every case, to our thousands of prosecutors. So I think that's very real. Beyond that, though, I think the bigger point is that when we prosecute in protest cases, or any of the sorts of cases that you mentioned, that's because the legal process and adherence to the rule of law requires it. Not for some political motive, but because applying exactly the same code tests that I referred to that we do in every other case, we have determined that there is a case for the court to consider. And I mean, many people on this call will know, but it's crucial to understand that we do not determine guilt or innocence. So when we're placing, let's say, a protester before the court, we're not saying they are guilty by some decision that I or the CPS have made. We're saying there is material here, evidentially, and it is in the public interest, as properly defined, for a court to consider this. And it is the court that will then determine guilt or innocence. So I think what I'm very keen on is not overinflating the role of the prosecutor. It is a key function, and in any civilized society, democracy, etc., you have to have independent prosecuting authority. So it's pivotal, and of course it sits right at the heart of the criminal justice system. But what we do is what we do, and I don't claim anything more than what I've set out. And the decision-making function, and indeed post-conviction, the decision on who goes to prison and who doesn't, that is not anything to do with us. Our role is to keep a court informed so that decisions are made in accordance with the law, and ultimately sentencing is in compliance with the law. So I think we should never overinflate our own position or our own importance, but nor should we be shy of saying that we are actually pivotal to the system, which is why, you know, my roles existed for more than 140 years, and we've had a unified national prosecuting authority now for well into the fourth decade, and that's a good thing too.
Thank you. Right, my last quick question before we turn to the audience questions. You're a former chairman of the Criminal Bar Association, who've just announced their No Returns campaign, and a 2017 Bar Council survey reported over half of criminal barristers would leave their job if they could. Half didn't feel able to cope with the stress of their work, and only a third would recommend the bar as a career. What would you say to any of our students watching tonight about a career in criminal law?
It's not always easy, and there is more money probably to be made elsewhere. If you are a grade A law student, which you are by definition if you're at King's, then there will be many other paths open to you. But in what other area of the law, either in a public or private practice, will you have such an impact on delivering justice? On what other area of law will you have such an impact on people's lives, you know, at the worst point, the worst juncture of their life? In what other area of law will what you do feature in the newspapers, online and off, every single day? And if you look at the Crown Prosecution Service, in what other area of law, and here I include solicitor's profession and the bar, will you have the extraordinary range of opportunities that is open to our legal trainees who come here? You can come in as a legal trainee, and you can end up as a liaison prosecutor in a far-flung part of the world with lots of support, dealing with extradition cases, mutual legal assistance cases, driving domestic casework back in this country by generating the material that we need from any corner of the globe. You can end up from the same starting point as a specialist in counterterrorism, in corruption cases, in economic crime, which is going to be a huge feature as we go forward. And we look at the bills that are going through Parliament right now. Or you can end up as a senior civil servant, but sitting within an independent department who has at their disposal, you know, as a legal manager, hundreds of legal staff, whether you're in one of our central casework divisions or our geographical areas. And you know, that's just for start. There are then all of the people who join the CPS not having a legal qualification or even a law degree, and all of what I've just described is open to them as well, which is why I mentioned the career pathways earlier. So, you know, when things are pressurized, when it's hard, and it's been made even harder by lockdown and COVID, etc., this is the time to come to crime. It's not a time to shun it. And, you know, I joined the CPS when there had been an unprecedented downturn in our financial resource. Everyone knows the headlines. From 2010 to 2018, when I joined, CPS budget had gone down 44%, headcount had gone down 30%. So all of the warnings were given to me. And my reaction to that was, well, okay, this is the perfect time then to try and see if, you know, in a small way, I can make any difference. And as it's happened, not through my effort, but through the effort of the organization and all the things I've described tonight, we're in a much healthier position with resourcing that will see us through the period of the government spending review from this year to 2025. When it comes to the external bar, obviously that was my home for a long time. Nothing that I say is intended to, you know, bear down on or minimize how much we need a criminal bar, how much we need a defense profession. None of our work would function without it. And I mean that in two ways. We need defense advocates, solicitors and barristers in all of our cases. And we need prosecution advocates externally because we rely on thousands, literally thousands, about 3,000 members of our panels who are in chambers as external self-employed barristers, but who make themselves available to prosecute our cases. So we're very much collaborative with our friends at the bar as well as solicitors. Yes, some have joined us because they've seen the sheer breadth of the opportunity here, and I would say the very inclusive view that is taken to all employees, but that doesn't mean we can do without the external professions. The CLAR review, the outcomes are nothing to do with us. I should say that we took part in the myriad of conversations that Sir Christopher Bellamy had as he was formulating his report. We made many of the points I've just made to you now. But the immediate future for that outcome sits with Ministry of Justice and with the bar and solicitor representative bodies, and we will simply wait. The only thing I would add to that is that it is important that there is parity in the legally aided, publicly funded area of law between prosecution and defence, and so we are watching very closely. And you would expect, I think, that if the CLAR outcome introduces any elements of disparity, we will immediately look at that and try to ensure that parity is maintained.
Thank you. We've got some really good questions from the audience, and if any of you have questions, then please do just type them into the Q&A boxes at the bottom of your screen. There's quite a few on technology. So you spoke on using technology to improve the criminal legal system. How is this digitization developed, and is it outsourced? Which firms were used, and does this risk giving us a de facto privatized criminal justice system?
What a good question. I wish our Director of Digital and Technology was sitting alongside me, but he isn't. So I am not a specialist in this field. That's one of the points I was making. This is one of the other 8 professions alongside law at the CPS. No, we're not privatizing the system or aspects of it. But clearly, as you would expect, there is a contracting relationship for what we need to give us the technological tools, the technological capability to not just keep us going, but to move things forward. And so there's very vibrant movement between private and public sector where specialists will come to join our teams. When it comes to contracting, we're a public organisation. Public procurement principles apply. There's absolutely no cutting of corners on that. Robustness is used at all times. Where I think, though, that we can continue to learn from the private sector in terms of digital tech and AI is to sit down and talk with those in the private sector about the tools that they have. And sometimes they have an enhanced capability in comparison to our own. And we can learn from that. And I think some of the AI sort of machine learning tools that are available, let's say, across the City of London, have not all reached us yet. And so we do reach out seeking to learn from that. But we have huge degree of specialty and expertise here in people who join us for the various digital projects that we are embarked on. So there's a lot that we do ourselves, and I just touched on some of the developments, including just sheer ability to do what we do from wherever we may happen to be, which is new, but is pretty remarkable. There's a certain amount that we can learn from private sector, but there are also some big initiatives which people may have heard of across the public sector to improve digital capability, and that includes the Common Platform Programme, and we will be a user of that just as much as the courts will, as and when that happens. But I should emphasise that sits with Court Service and Ministry of Justice to deliver, and not us. So I've sort of scratched at that answer because I don't have the technical capability to give very specific examples. But if the thrust of the question was, are we going to privatise? No, we're not. But I would go so far as to say, where we're talking about redaction, which I did touch on, we are interested in using the right tools to make sure that data protection legislation is used appropriately at all times, and that we try to at least lessen the burden on the humans who have to sign off any document that we put through the portal to provide to defence and to the court. And I do think there's more potential there, and we will continue to explore that.
Thank you. Next question follows on really well. We've had a great focus on victims, particularly rape and sexual violence. What's your opinion on recruiting other professionals to the CPS, such as victim care officers, independent domestic abuse, sexual violence advisors, to work with prosecutors in terms of how to improve the criminal justice system?
Yeah, I think I give a very clear answer on that. I am absolutely in favour of the people that you've mentioned, but fortunately, it's not a matter of us having to offer employment. The key there is local commissioning, which actually sits under police and crime commissioners, and where money is spent at a local level with any of the 43 police force areas of England and Wales, it brings huge benefit when that third sector commissioning includes IDVAs and ISVAs. And IDVA is an independent domestic violence advisor, and ISVA is an independent sexual violence advisor. They, generally speaking, not legally qualified. They don't work for the police. They don't work for us. And actually, to answer the question, that's their strength, that they're not under contract of employment for us. So there couldn't be any suggestion that they, lack independence. What they do, though, from first point of complaint, for example, at a sexual assault referral centre called SARCS, where a distressed victim or survivor will attend, the ISVA in that case can help victim, survivor, complainant with every step of the journey from that moment through to when evidence is given in court. And I think that they are gold dust, which is why even during lockdown, I was visiting places like the Haven in London remotely across screens to talk to the clinical professionals there, as well as the commissioned ISVAs, because they are one of our best hopes, actually, in giving confidence to victims in the system and doing sometimes what lawyers find more difficult to do, which is to explain in plain English what's happening and what's going to happen next. So we have a really valuable and vibrant relationship with ISVAs up and down the country, and they are absolutely part of the future here. And long may they continue. Unfortunately, we don't have to employ them, nor would it be right to employ them. They're great as they are, independent as they are.
Thank you. Question here. You talked about the need to triage and prioritise cases. A lot of offending is minor in nature and or is committed by those who have limited culpability. Do you think that greater use will be made of diversionary strategies in the future?
Yeah, good question. I mean, we have what's known as a conditional cautioning scheme, which runs up and down the country. It's not in use in every police force, but there are, I think, 10 that actually I signed off. Chief constables came to me in 2018-19 and said they'd like to run a conditional caution scheme. It's for specified offending only. So just to be clear about that, you wouldn't have a conditional caution scheme in a murder case, but you might have it in something less serious, including, for example, shoplifting, theft, the sort of person I think the questioner is asking about. And so those schemes have been running. And so diversion away from prosecution can be a very valuable outcome. I mean, we're not here for diversion, we're here for prosecution. And back to what I was saying earlier, it's not for us to expand our model or to claim greater role in the system than we're here for. We're here to prosecute fairly and independently. But if you do broaden the system a little, I think that non-prosecution outcomes can be very, very valuable. There are some red lines though, and there are vast swathes of offending where if it was suggested that conditional caution should be used as a matter of routine, I'm afraid we'd be saying, well, for example, if we're dealing with actual violence to the person, whether in a domestic abuse setting or on the street or anywhere else, you'd need to think very carefully before you took a non-prosecution outcome. And we would be dictated by the relevant laws, the offending that's happened, the likely sentence that any judge would have to consider. And so that naturally puts, into certain categories, vast swathes of criminality. But I think, again, to go back to the question, where we are dealing with, I think, what was being called minor criminality, although you have to define that, there is a place in diversion. We're not here as a society to criminalize everybody at the first point of contact with the criminal justice system. But by the time things come to the Crown Prosecution Service, particularly if it's Crown Court business, very often that point has been passed and there is no other option but to prosecute, in the knowledge that it's not us, but it's the court that makes the decision on guilt or innocence, and a judge will always have discretion on the outcome. So it's a big topic, actually. It's a very interesting topic. But those are the deadlines.
Do you have scope to push a case back to the police if you think a prosecution isn't necessarily?
Well, there are two basic models that the police will use to come to the CPS. And this is bearing in mind that actually in minor crime, we're talking about that, there are vast swathes still where the police make the charging decision and they don't need to come to the CPS. So there's lots of crime which is charged without referral to the CPS, and I'm not complaining about that. That's the way the model works. We've been doing more than before since the creation of the National Crown Prosecution Service, but the police still do a lot of it. When, however, they do refer to us, there are two bases on that. One is for what we call early advice, sometimes called investigative advice. So the police are entitled, they don't have to, but they are entitled to come to us to say, this is the investigation we've got. Can you look at it from the lawyer's perspective in terms of the elements of the offence, the necessary evidence? And that will often help on the journey to working out whether this is a case that's going to be charged or there isn't sufficient to charge. So that's category one. Category two is what we call a full code test referral. So this is effectively at completion of investigation, the police will transfer their digital file and materials to us, and our prosecutor, often very quickly, will determine whether there's evidential sufficiency and it's in the public interest to prosecute. So there is movement between us and if we're looking for examples of where we would push back, if you like, I don't think it's necessary for us to say this is the community disposal outcome that you should be using, but there are absolutely cases where we will say there's a certain amount of evidence here, but it's not in the public interest to prosecute. And the factors that we bear in mind include age and maturity of the offender, and that is a public interest factor, as well as the picture prior to this. So I think the short answer is yes, we do send cases back, but it's not for us to dictate what should happen. What we will say in the right instance is that even though some evidence has been gathered, it's not in the public interest to prosecute. Although I have to say in far more cases, we will say the evidence having been gathered, particularly if it's serious criminality, there is very strong public interest in prosecuting. Hard to think, let me give an example of any rape case in which it would not be in the public interest to prosecute. So if the evidence is there, we will prosecute.
Thank you. A very future-looking question to finish with. What advice would you give to an applicant for the legal trainee scheme?
Go for it. And be aware that there's heavy competition. I meet all of our legal trainees, so there's the prize, you get to meet me for what that's worth. But in our competition last year, we took 40 legal trainees and there were 4,000 applicants. So it's a 1 in 100 chance. Because I've been in the room and looked at the backstory of our legal trainee, our new legal trainees, there's a lot of really first-class people there. So to expand on the answer, for all of the reasons I gave earlier about the cornucopia of possibilities at the CPS, you should consider it. You should look at it. And to anyone who says, well, you didn't 30 years ago, I think that was a different time. Okay, a fledgling CPS, it actually opened its doors, I think, 1 year before I went into pupillage. That was then, this is now. We've really grown up in a host of ways. Although I would add, we've got some fantastic people here who've been here for 30 years and are still going. But for the sort of the next generation, just as in an application for the bar or for a training contract, you need first-class qualification. I'm not saying that has to be a first-class degree, many do, but not all do, but you need more around that. So you should be thinking creatively about how you can demonstrate why it's not just a legal education, but a legal career that you want. Use any avenue open for other work, which can be shadowing possibilities. Many pupillages at the bar, many people undertake that sort of thing. NGO work in legal sector. Often people have higher qualifications. So many now will have a master's level academic qualification, either in law or before transferring across into law. So you've got to show your journey. But if you're interested in anything that I've said tonight, this is a great place to be. And the working life that prosecutors have, even though there are elements of it in the public eye, and the protection that we put around our people makes it very inclusive. It's extremely diverse. It's extremely socially mobile. The staff networks that we have include disability staff network, which is absolutely thriving. So whoever you are, wherever you come from, please look hard at the CPS. It's not for me to give anti-bar messages. How would I? I owe my career to the bar for 30 years, but I can tell you that there's so much here that you should take it really seriously and look at it. And that is why in successive surveys conducted with 10,000 students intending to come to law over the last 3 years, the Crown Prosecution Service has been listed as the #1 employer of choice. So I'll leave it at that.
Finish on a high note. Thank you so much. That's been absolutely fascinating. I'll pass back to Professor Turk to thank you officially on behalf of the school and the college, but thank you very much.
Thank you, Hannah.
Thank you so much, Max, for your rich and thoughtful insights in how the service delivered criminal justice in very difficult times and how you intend to do so in the future. Now, before I conclude, let me just basically make a few comments. There are obvious differences between the service that you provide and the CPS provides and higher education. But of course, there are also some similarities. In a sense, we both provide a public service. I think we both grapple with instances of finding the right balance between remote working and in-person delivery of the service. And we also grapple with the role of technology and what we want to maintain that we have learned is good about it and what we actually need to be mindful that can better be done in person. But it is also a very good reminder in this talk, and both you and Hannah forcefully reminded us of that, is that at the heart of what we do are people for who we work with, our staff, and for the services that we deliver. And in your basically case, more complicated because you have witnesses and victims and defendants and their rights need to be balanced. So in addition to effectiveness and efficiency, we always need to be mindful there also needs to be fairness and there needs to be empathy. And I think that is basically something that should probably guide us all in the delivery of a public service. So with that, thank you so much. And thank you also very much to your staff who basically helped us deliver this event. And many thanks also to Hannah asking the questions and dealing with the questions from the chat, and also to Chagong here as the director of the PLI, and Nathan Marshall, who basically made this event possible, and also to Louis, Ethan, and Stephen from our wonderful comms team who have been involved behind the scenes of making this talk possible. And thank you very much to you, the audience, of listening. What I all hope you agree with me was a a great insight, and it was wonderful to have you, and it was a great privilege to hear you speak. Thank you so much.
Thank you very much. It's been my pleasure.